looks like we have some folks trickling in just a little bit here. So I'm going to go ahead and get us started because we have a lot to go through for sure. And we want to make sure that we can be respectful of your time and really just give you this hour of content and then move on. So first things first, I am Amanda Erickson. I am joined by Jeannie Valier. We are the owners of HRX Services. We are a really high-level service HR consulting company. We work with organizations to really help support their HR needs and work as a partner alongside their teams that are working in that function. We've been in HR for a while and we are very passionate about this space. So we know a lot about kind of what's happening in this space around the state of Colorado. A couple of things to keep in mind. First, although we know a lot about HR and we're passionate about the profession, neither one of us are attorneys. And so everything that we are saying here today should be considered best practice. And if you do have any type of legal questions, we always encourage you to go and connect with those partners that you have for your own organization around your own particular questions. So just keep that in mind. Nothing here should be construed as legal advice. Additionally, we are recording this session, and so if you do not want to participate in a recorded session, we would ask that you would exit the webinar at this time. That said, it really is a webinar tool that we are using for this session, so you're going to see some functionality that might be a little different than the Zoom meeting functions you've normally seen. And so you will have a question and answer box that you can put in any questions that you have. That will allow Jeannie and I to be tag teaming in there and trying to answer those as we're going through the presentation. It also allows us to pull that report at the end of the session and then circle back on any of the questions that we maybe didn't get to, which is maybe likely today. We do have a lot of people on this call. Thank you for joining us. And like I said, a lot of content. We will also be managing the chat, which you will have the ability to write into. It will come to both us and all of the other attendees, whereas the question and answers is just to Jeannie and myself. But we are really looking at that Q&A box as far as making sure that we're answering those questions that you may have. Okay, without further ado, we will go ahead and get started. Jeannie, do you want to say hello really quickly?
Good morning. I see a lot of familiar names on here. This is very exciting.
Good. Well, then it should be exciting and fun. Let's go from there. All right. Well, I'm going to jump right in. We're going to start first with the Equal Pay for Equal Work Act. So this is a new law that is going to start January 1st, 2021. So that is, within weeks of where we are today. The Equal Pay for Equal Work Act, really the goal of the act was to avoid pay discrimination based on sex or sex and another protected class for doing substantially similar work. Instead, the law is really requiring that we are going to be measuring competencies and skills, effort, and responsibility in order to have different compensation levels within the same type of position. So just something to keep in mind as far as how we're walking through this. So let's start first with a little bit of history. I always like to give a little context behind this just because I think both it's exciting and fun, and it also gives us a path for moving forward. So first, how did we get here? A couple of things to know is that we have legislators in the state of Colorado, similar to how we do in the federal side. However, in our legislative system in the state level, all of our positions have term limits. So what that means for us as constituents in this space is that our legislators do cycle out. They turn over, and even though sometimes they're still there for a while, they aren't there forever. They are not career politicians, at least in the same category they've been in. So a representative can move to a senator or from a senator to a commissioner or something like that, but they do switch roles. What is also important to note about that is that the Colorado legislative session only goes from January until the end of April. That's significant because you need to understand, and I'm sure you all remember the song about a bill becomes a law and going up Capitol Hill, whatever that song is. you know that there's quite a process for a bill to become a law. And so we have 4 months with really which to pass a bill and go through the House, the Senate, be signed off by the governor in order to make it a law. So it is a very short period of time. Why is all of that important, you might ask me, and why, Amanda, are we spending time on this? I think it's important because we need to remember and understand that every time that laws are created, there are things in practice that aren't necessarily being considered when they're being written. And so we're going to find some gaps or holes or things that we're like, as practitioners and administrators of these new laws, wondering, how do we move that forward? What did they mean by this? Some of that is the stuff that we find through practice, okay? So just keep that in mind as we're unpacking this today. There might be some things that don't make quite as much sense as you'd like it to, but that's just the nature of the beast and a little bit of where we're at in our legislative process. The other thing to note is that Equal Pay Act, so even though this is a new law starting January 1st, the Equal Pay Act has been around since the 1960s. Is that right, Jeannie? So the
1963, I think.
Yeah, somewhere in there. But for decades, we've had a law that has said it is not okay to pay men and women differently for doing substantially similar work. So there's a federal guideline that already exists. However, back before that guideline was in place, it was 100% legal and practice that women, for doing the same job as a man, would get 50 cents to the dollar, let's just say. And that was 100% the strategy until this law came around and they said, nope, no more, you can't do that any longer. But there wasn't a lot of qualifications for what that meant. It was just, don't do it anymore, and that was it. So here we are, 2020, and I think we're now at like 86 cents to the dollar that women are making statistically to their male counterparts. And that's just the statistics behind it. So what Colorado has said is, we're not getting there fast enough. And so what we're going to do is we're going to create a new law that will have more parameters, more regulations, and more structure so that people know how we want it to be, quote unquote, equal pay for equal work. So in the state of Colorado, generally when that compliance is issued, as the legislators create the law, they are not the ones that are then kind of policing the law. That is handled in the state of Colorado by the CDLE. So in our state, the Colorado Department of Labor and Employment is kind of the place where they're going to look at claims, they're going to do investigations, and we've recently received adopted rules from them where they take the law and say, okay, what did the legislators mean by this? And now we're going to put it into practice and put some guidelines around it. But at the end of the day, Jeannie and I, we always come back to this, is the proof is in the pudding. Where we're really going to learn how this law comes together is in litigation. And so when we don't know exactly where those holes need to be filled in, that's when the Supreme Court comes into the play, and we have our different judicial system, and we've got our different level courts who come in, and then they start to litigate cases that come through with regard to this law, and they build what's called case law, which then allows us to look at how the courts have ruled to help us understand and fill in those gaps. So it's quite a process. I share that with you because I think it's important as we walk through this today. So let's continue and talk about adopted rules. Woohoo! So we've been working on this. I think Jeannie and I first went and testified on this, was it 3 or 4 years ago when it first was introduced?
It was a while ago.
Yeah. Several years. And so this year, when it was passed, and then we started to really look at it, where those holes were. This is the new, released about a month ago from the CDLE. These are the adopted rules with some of those clarifications. So when we're diving into it, let's talk about what the requirements mean. And we've added some of those adopted rule qualifications in as well. So the requirements, the big ones, the way that I look at it, is we've got money requirements and position requirements. So we've got the money side, which says basically, as an employer going forward, you are no longer allowed to seek wage history from your candidates. So when you are looking to bring someone into a position in your own organization, Wage history is not anything that you can ask about any longer. So what does that mean in practice? Jeannie, what are some of the things that we need to look at then to make sure we're not asking about wage history?
The low-hanging fruit, I think your job applications for sure, your online applications, and my personal favorite, when you're interviewing people, the manager or the hiring person says, so what did you make before? So those are the three most obvious.
They are. And even if you're in the HR team, and we've done this a lot of these trainings with our clients, we know that even though we've done this with our clients, they found that people were still using out-of-date applications because they're using what was on their desktop from 5 years ago, or they're using the paper application at the front desk and it's just being passed along, and that is asking for previous wages. So those are the things that you need to kind of be thinking, soup to nuts, where could this all be? And making sure it's not just you and HR, but it's you, HR, managers, however that hiring process is occurring today, that there is some education around that for those folks. A couple of other things that are required. You can't prohibit wage discussion. So any longer, in fact, this is something that, as Jeannie has shared with me, and my education growing up, is that we've always had the ability to talk about our wages in our workplaces. That has been a protected action. But I think overall, there's been a real kind of a stigma around that. It's just kind of bad taste, bad form to be talking about your pay with your coworkers. However, in this particular law, it is not only 100% protected, but we're going to see it being encouraged in a lot of different areas and a lot of different places. So just know that it is 100% protected for your employees to talk about what they make with their coworkers. And that's going to be a new change for a lot of organizations, pretty much like culturally mostly. But if it's in your handbook, if it's in things like that, those are the things you want to be looking at and reviewing to ensure that you aren't out of alignment in your compliance in that area. Okay. The other thing is that they also have a requirement of ensuring pay equity. This means that they have said that there's a good faith method that if after 2 years, you do a pay analysis. So that means if you did a pay analysis right now, you'd be good for 2 years, and then another one 2 years, and another one 2 years. That being said, this is really just to see if whether or not what you're paying in the positions that you have are considered fair and equitable, and that you're paying people for doing substantially similar work similarly, or the pay differences, again, are aligned with this new position or this new law. And then tracking wage history for every employee, not necessarily new. I think that we can do that. A lot of our payroll systems allow us to do that. However, the second part, and I'm going to skip to the bottom here on the position requirements, is that what is new is that you need to keep job descriptions for every employee in their personnel file and keep it tracked to any type of promotions, position changes, things like that as they move forward. So I do think this is a new thing for a lot of employers. They may have had a list of job descriptions before, but keeping it associated with a wage history and in the personnel files is very, very new. But you're going to want to have that in case you are ever audited for any reason, and you can kind of defend how you've moved that person forward. The other big pieces is the position requirements is you also need to communicate positions with pay, and in the adopted rules, a general description of benefits, which needs to include things like health and welfare benefits, 401k, retirement, fringe benefits, things that are kind of substantial. You don't need to include that gym membership, right? Like that's de minimis, but that's still pretty much kind of the comp plan. So you want to be thinking about that comp package and how you want to make sure that you're relaying that information out. The other big piece of this component is that there is a requirement to post promotions internally. So this means that gone are the days where maybe you did have somebody in mind, you thought they'd been a high performing employee, and you had a new position that you wanted to create or was going to be vacated. And so you decided, we're going to go ahead and promote that employee. We're going to let them know, they're going to be really excited, and we're going to announce it to the world after the change has happened. This is no longer going to be compliant. What will need to happen instead is that any promotion opportunities that you have, and again, soup to nuts, so receptionist to CEO, will need to be posted, at least internally, with, again, pay range and your general description of benefits. Again, you don't have to put that gym membership in there, but you do have to have all of the other things. So this is a big change. This is a big shift for a lot of companies and something you really want to understand. And I'm going to go through really quickly why it's important. And I'm going to ask Jeannie to share the most important piece. Go ahead, Jeannie.
Can we actually jump back real quick? I'm going to answer a couple of these questions as a reference here. First of all, don't prohibit wage discussion. So we had someone ask, what if during the interview they offer their wage, like I make X and I'm looking for Y? You know, I actually spent 4 hours of quality time that I may or may not ever get back listening to the public hearings. And this actually came up and they said, well, the best practice would be to close the position because now you as an employer, you as the hiring manager have heard information that could potentially have an unbiased or a biased decision-making implication in who you hire because now they have shared how much they previously made. That is the best practice. I mean, you should probably close the position, repost it, start the candidate pull over again. If the job description is the same one, but the same one individual performs well above another one, do you pay this, or do you have to pay the same? So this is kind of this comes up often. If you have a job description and you have two people in the same job and one is exceeding the other, hopefully, and I don't know, I think you go into this a little more, and so we'll cover that a little more, but now you have to have good metrics in place and performance and things like that. If in your view, how does promotion postings affect succession planning? So there's some caveats to this posting promotions, and it's very limited. I mean, it is exceptionally limited. They did put some carve-out exclusions saying, hey, if you have a confidential search, i.e. someone's in that role, let's hypothetically say the CEO is in that role, they're going to retire and you need to go out and make a search because maybe if it became public knowledge, that would impact the company financially. If it came out the CEO was leaving, you do not have to post it. However, it is very, very exclusive and specific as the example. And then also the other carve out, which was maybe you hire an operator 1, and within the first 12 months, you know their goal is to be an operator 4, and you have a glide path or a promotions path from 1 to 4 in the first 12 months of their employment, and that is the key, the first 12 months, then no, you do not have to post those positions, but it has to be written in their job description that is the path, and it has to be done in the first 12 months. I think that's got all of the questions that we had on there. I also want to, one more, prohibiting wage discussion. There's a little nuance to this because the comps order has now done a lot of clarification on exempt employees. Previously, the NLRB already said non-exempt employees could talk about their wages and they were encouraged. Now they're saying exempt and non-exempt. You cannot prohibit that wage. So it's either or. That's managers too. So I think I got most of them.
I think you did. I think that there's been the couple questions that I saw is just that, can you ask what someone's salary expectations are for a position? And our understanding is yes, absolutely, because that's not asking what they were at before, but caution you in practice when you start to say, what are your salary expectations? Very quickly, it is very common for your candidate to respond with, well, I currently make. And that's where you get into that rabbit hole. So again, one of the things to just in practice look at least what I do, is somebody starts to say, well, I currently make, I say, you know what? It doesn't matter to me what you currently make. What is it that you are looking for this position? And so it really does, you got to be kind of on your toes and be ready to do these things, because those are things that in practice are going to be challenging as we move through this dynamic shift. So very good. I think the only other exception with having to post promotions internally is if it's like a temporary position.
Correct.
Unless
and
you
it's
are
less than 6 months.
If you decide you're going to go further than that, or you're going to make this a more permanent position, or the minute that anyone else knows that CEO is going to be rehired, or if you're not going to push that person into that next promotional position, the minute that changes, you've got to post. So just keep that in mind as you're walking through these processes that, like Jeannie said, it's very, very narrow. So you might be asking me, well, I'm a risk taker, Amanda. I am open to some risk. So let's talk about the risk just for a little bit. So violations of the money requirements, the dollars and cents, right? These are the requirements. You can't seek pay history, not prohibit wage discussion, ensuring that pay equity piece, and then tracking wage history for every employee. So you don't do those things, it could result in economic damages, liquidated damages, which I'm going to come back to in a minute, legal and equitable relief, and then reasonable costs, question, right? So economic damages, you need to understand that the max on this, at least that I think we've heard, is that it could be 3 years. I think it's standard 2, but there are some caveats. So let's take 3 years. And let's say that you had somebody who's supposed to be making $2 more an hour than they were. They file a claim, you go through the process, then that's determined. Then let's say that then is 3 years back pay. So now you're talking about $15,000 for $2 an hour wage difference. If it's determined that you did not operate in good faith, you didn't do this pay analysis, you didn't try to work through these things, you knew you didn't have equity. If it's determined for some reason, well, let's say you don't have those good faith qualities on the back end, you can also be assessed liquidated damages. And in employment law, liquidated damages is equal to economic damages. So your $15,000 liability is now $30,000. Plus, we're gonna probably throw in that legal fees and court costs. And then reasonable costs, right? Question. In my mind, reasonable costs are things probably like maybe the cost of benefits were different. Maybe there's some other things, what were those fringe benefits you didn't get with some of that extra money? So those are the things that really, this can add up pretty quickly. We're a small business. I'll tell you, $30,000 impact would be significant for us, right? So I can't imagine there's a lot of companies out there that wouldn't be significant to. For really no other reason. So just something to kind of think about and try to look at how do you square those away. So violations of the position requirements, again, those requirements being you've got to communicate your jobs internally with some exceptions, posting those jobs with pay rates and the description of benefits, and then keeping the job descriptions for every employee. You don't do those things, your liability would be a fine from anywhere between $500 to $10,000 per violation. So this means one job posting. So if you post one customer service representative out there on a couple sites, all right, that's one fine. But if you post a CSR 2 and a 3, those are 3 fines. So the minute you start posting out into Indeed, Craigslist, wherever you're going to post your Facebook marketplace, wherever you're posting your positions currently, if you do not have a pay range associated with that job posting, you will have a potential violation. And the money penalties to that is anywhere between $500 and $10,000. And people say, well, Amanda, what's the difference? And I say, I don't know, the judge you get that day, or whether or not you had that good faith. Again, these are the things we don't know, but it could be significant. So one more thing that, again, when you're talking about these are not little penalties, these are big dollars. And that's why this law in particular is so significant. In addition to some other things as well, which we will get into as we move forward. So these are the things you really need to be thinking about. At the end of the day, what does this mean to me? Jeannie, what is it that we're trying to avoid more than anything? You've already addressed the fruit in the room, right? But what is it again? The low-hanging fruit, right?
Oh, I'm like, the low-hanging fruit. Well, again, so I had the opportunity to participate in that public hearing, and I got to listen to a lot of attorneys get up there and say, and we are ready on January 1st to start trolling. They didn't use the word trolling. They said reviewing the internet for job postings, and they will identify all those employers that did not post the salary range or the pay rate. They made it very clear, and the CDLE also supported them. They said, that's great. Help us, enforce us, because guess what? It's not just the CDLE, Amanda. The other thing about the way this law is written is they can bypass the CDLE and go straight to court and do private action. Unlike federal law, you have to go through Department of Labor or
process, yeah.
You have to go through the administrative process to get a right to sue letter, things like that. This particular law, which by the way, this equal pay law is the most stringent in the United States, even more so than California's.
It is. It is a robust law. There is a lot to it. And as Jeannie said, the suggested path for a person who's in your, so let's say you're an employee in a company and you think, I'm not making as much as John, and I don't think that's right. I think I should be making more, or I think I should be making as much as John, and I just think that. Normally, the suggested course, and it is in the law, the suggested course is you go talk to your manager and you see if there's an issue. If nothing happens, then you can report it to the CDLE, again, the governing kind of entity in this situation. And you go to them and you report it, and they can go through a whole investigation claims process that they have outlined. And then they could issue you the right to sue letter, in which case you go find an attorney and say, I have a case, and they're going to come and help support me, and we're gonna litigate this, and I'm going to sue my employer. What this law in particular does is it says you can go straight, you don't have to go past go and collect $200. You can go straight from, I feel like John makes more money than me, and go find an attorney. So that is why this is so significant, is that there's not a lot that is required to kind of start that process moving forward. And we know that there are people who are very educated about this law who are going to be looking at those sites to see who may not be in compliance or totally aware of what's going on. So that's the part and why that Jeannie and I are so passionate about really trying to spread the word. Let's put it
right, for sure.
We don't want, at the end of the day, we just don't want you to be the one that everyone else is learning from, right?
We don't want you to be that person. Something else that this came up yesterday in another webinar we did or last week. I think everybody thinks this is all about women making equality, and we should be very clear. It says sex. So you could have 10 women being the higher earner and one male who's not, and this law applies to that one male. So this isn't, we've got to bring all the women up. It is pay equity amongst sex. So I think that's another thing to clarify and keep in the back of our mind.
Agree. In fact, we've seen it in practice where a white man actually was increased by like 52% because of pay equity issues. So this is, it's not one way, it's all around pay equity in general. So these are the real 4 areas that we are kind of talking about. This impacts a lot: hiring, promotions, comp strategy, and your record keeping requirements. Now we're going to spend the next hour going through each one of these. No, just kidding. We're not going to spend an hour going through this. This is a lot to unpack, but this is our process as HRX. It's involved. So that's why, comp strategy is not easy. It's definitely a bit of an art, but there is a lot of math and science to it too. So really understanding how to do that is going to be important for how you move forward in your own organizations. So we usually start with the strategy. What are you trying to do? What is your overall goal in your organization? Are you trying to lag the market? Are you a little below that 50% midpoint? Are you trying to match that 50%? Or are you trying to go ahead of it? What does that strategy look like? And if you're not leading and you are looking at lagging, what are the other things you might be offering? Are you a startup or are you really, really well established? Those are the things you've got to be thinking about and really looking at then what positions do we need? What are the buckets that I need to be looking at in order to develop a great organization? According to the law, there is a yardstick of qualifications. There are these 6. There is seniority system, a merit system, quality or quantity, a geographic area, education experience or that training piece, and then travel. This is it. This is how you can differentiate pay. What is not in here, for example, is what they've made before. What is not in here, for example, is, well, it was a recession, so I got that person really, really inexpensive. And then we had an unemployment rate of about 2% for the last however many years. So I had to pay more for the newer people coming in. That's where you're going to find those significant issues if you haven't already leveled them out, and where you're going to have those people who you hired back in 2008 and 2009, 2010, when the market was pretty hot for employers. And then it wasn't so much in the last few years. That's not going to be defensible anymore. And so you really need to understand the concept of all ships rise with the tide, where if you do find a pay inequity where someone is making significantly more than someone else and they really have the same skills, knowledge, ability, performance level, whatever, that's going to be an issue. And the goal is not to move that person down who might be overpaid. It's now moving that other person up, or any other people that may need to be there as well. So just really quickly going through it, the seniority system, obviously kind of how long people have been there, that type of thing. Your merit system, it's my favorite. Everyone kind of uses this merit system idea, but even if you talk to Jeannie and I, we have different ideas about what is the merit system. And it would also preclude then that you need to have some form of key productivity indicators, some type of analysis, training of your managers so that you know that all managers are being unbiased and it's not subjective, it's very objective when they're talking about it. And most importantly, that you're doing some type of review process. So like a performance review or, some type of one-on-one, something where you're tracking that information so that you could defensively say, where someone is performing better than someone else, or they deserve a merit increase versus someone else. Those are going to be the things that are going to be important. So that's actually very, very subjective. So something to kind of consider. Quality or quantity. We see this a lot in like kind of piecework, or we've even seen it in like the trucking industry where it's based on how much you deliver and the loads, or, like food production. I've seen that where it's how much food you pick. And at the end of the day, if you produce so many product or pieces of produce, you get more money than your counterpart. That's pretty easy to measure. Geographic area, we talk about that like in relative terms when you're looking at benchmarking and actual external data points. I'll be honest, Greeley to Fort Collins is not that different. Now, Greeley to Denver definitely could have some differences. So you really have to understand what that geography looks like. And I think there's a little TBD on this as to what qualifies as a real geographic distance. And then education experience or training, pretty easy to kind of look at, whether you have a high school diploma or equivalent, you've got associate's degree, bachelor, master's, that kind of thing, or experience level, like how many years of experience. This is where your job descriptions are very important. It's where you start to distinguish what you're looking for, what are the required skills, and then what will you pay for, because that is the bucket that matters the most to you. So those are the things that you really have to be looking at when you're identifying your job descriptions. And then whether or not this person is a road warrior out on the road all the time and having to like move around, or, they get to work, 5 feet from their bedroom and have a remote work option. That could also signify a differentiator in pay. So this for us is like when you're starting to talk about creating that comp model, how we do it, like grouping different positions, creating job grades. There's a lot here you can look at. Am I going to have position grades like a CSR1, a CSR2, a CSR3, and then I'm going to narrow that focus. And so you don't have a lot of room to move in there. That's very challenging in pay equity, just as an FYI, versus having just a CSR range where you broadband and you might have a big spectrum. That might be helpful in pay equity. There's just a lot that really needs to be determined when you're looking through this. But I know that we're trying really hard to make sure that we are going to get through and get all the way through some of our other laws as well. So I know that I'm glossing over this a little bit high level. So if you have further questions, put them in the Q&A. And again, if we don't get to them, we'll circle back with you. Benchmarking, what you might also see on the left side of the screen here is also a SWOT. So there's a lot of focus and compensation between what the external market looks like and what you are doing internally, but they really blend together. And that's part of that process when you're looking at what you want to establish for your compensation strategy as an organization. And then you need to get good tools if you're going to use some type of market data, because if you're going out to Glassdoor, salary.com, or even for some examples like the Bureau of Labor Statistics, which is great, but a little bit out of date, right? We got the 2019 information, I think in March. So that was back in 2019. I mean, we're a little dated when it comes to that. Some of those Glassdoor or salary.com got to be a little bit careful because they have crowdsourced data. And I think that Jeannie and I we think that we prefer having data that's sourced from controllers, HR resources, people like you, people like us, that that data is going to be pretty valid. And so when you are looking at exploring tools, or even if it's industry specific, sometimes you need to get an industry specific type of market data in order to really compare where you're at. But if your data is a little bit old, then you need to understand how to age that data, because it's not going to be as relevant as it needs to be for moving forward. So those are some of the things that really, when you're talking about pay equity, it becomes a big thing. And so it's something to really think about, but these are good things to do in your business in general, just to have some good understanding of where you're at. It really can help you move forward in a logical and strategic way. Now, from the back end, we always look at that piece where that's that good faith that we were talking about. And that good faith piece really comes when you do some type of pay analysis. How involved that needs to be, whether or not it's something you choose to do, you hire a consultant to do, or you look at an attorney. Having an attorney do this type of work for you or with you gives you that attorney-client privilege, something to think about, especially if you are concerned you might really have some issues. You may want some protection around how you do that pay analysis. For us, we typically start with like a standard deviation. We're starting to look at some of those statistical anomalies. Now we're getting back into stats, which is very fun. I mean, we could spend the rest of the time talking about stats, but we're looking at what is statistically significant when it comes to pay inequity. And so running some of those data tables and understanding if you have any risks or any flags or things that maybe you need to look at further is maybe a good starting point. And then looking beyond that further and doing some real analysis into whether or not you really have a pay equity issue with, based on sex or based on age or something else. So those are the things that really, when you're talking about that comp data analysis, can be pretty involved. So the last thing that I try to share is that communication piece is going to be key. Again, your employees are going to be very communicative, whether or not you want them to be. That is definitely going to be there. So I think Jeannie and I have always talked about how transparency and being as transparent as you can and as you are comfortable is going to bode well for you. Because once you've gone through this process, you've developed your comp strategy, you've figured out how you're going to do this, you know what your job grades look like or what your broad banding might come out to look like. If you can communicate that to your employees, then no longer is Amanda going to be like, I know that John makes more money than I do, but I know why. I know it's because John has been here for 5 years and I have not. And I know that because I know how I get to earn my money. It's very clear, it's transparent. I understand what that compensation looks like. I know what I need to do in order to move up. I'm very clear on that. And that puts a lot of the onus on me and me in the driver's seat. And now that transparency can be more helpful. I can say that I've used it a lot when we've helped our clients work through recruiting some positions. No longer are we doing the dance, so what do you want to make? Well, I don't know. What are you paying? What are you going to make? What do you want to pay? You don't have to do that dance anymore. It's very easy for me to say, I understand that what you're looking for is $60,000. We have comped this position out for our company, for our compensation strategy, and based on the market rates that we're at in this place, at 53. That's what this position will pay. That's what we're going to offer. And if that's not in what you're looking for, doesn't mean that you're not worth $60,000, but this is where we're going to be. And I'll be honest, I haven't had to negotiate one salary in the last 6 months because it's been very clear and very transparent for us to have those dialogues with candidates. And sometimes they're like, no, I'm looking for making a change. So this is a lower level position than when I was at before, but I'm going to learn some new skills. So I'm okay with that pay range. And others are like, nope, not into that. And that's okay. Then we're done. And it's a really easy conversation. So that's the thing to think about, that there are, even though this is very challenging, there's a lot of changes and moving parts. There might be some easier pieces to it once we kind of get it all flushed out. Last but not least, again, we've kind of mentioned that we've been doing some training with our client teams. I think this is going to be key because even if you as the HR person or as the leader in your organization know this, you are not always the person talking to every person or every candidate. So it's really important to make sure that they know you need to be involved. Like, you can't just create a position and tell me about it when the person starts the next day, right? How many times have we run into that situation? Who are you? Oh, you started today. Okay, all right. Let me run that background check, right? Things like that. You're no longer able to be out of the loop, so to speak, and make sure your organization is in compliance. So those are the things that we really want to make sure that we're talking through as well. Okay, last but not least, job descriptions, wage history for every employee need to be kept for up to 2 years past termination, meaning that every job change, things like that, and then someone separates from your organization and they decide that they're going to leave and move on, greener pastures, whatever that might be, you will need to keep that information for at least 2 years. This isn't new. We have payroll records and other things that we need to keep for a period of time anyway. But what is new is that job description piece and making sure that that's in there as well as part of that audit history. So I know that Jeannie has been amazing in the background answering tons of questions. So I'm going to say, moving along, I am going to turn the microphone over to Miss Jeannie Valier, and you let me know when you need me to forward things for you. Okay?
Okay. Well, you know what? We got 15 minutes, so we're going to do like speed dating.
How to be fast.
Yeah. So let's go ahead and flip a slide.
Okay.
Okay, so sick leave, purpose behind the bill. You know what? Nothing's popping up there. Okay, there we go. Very similar nature as to why equal pay was, but at the end of the day, they wanted to overhaul and provide sick leave. I think this was, by the way, in motion before COVID happened. This was something they were already looking at last year. I think the pandemic just kind of moved it along a little bit quicker. When does it take effect? Well, that's probably, how does this impact me? So if you're an employer with 16 or more employees starting January 1st, 2021, you will be required to offer paid sick leave to all your employees, full-time and part-time. If you're an employer with one or more employees starting January 1st, 2022, you'll have to offer it to full-time and part-time employees going forward. There's some carryover requirements. It's up to 48 hours. So for example, if they go the whole year and maybe they only used half of it, then the remaining half balance would carry over into the following new calendar year. So if you don't have a payroll system, or if you don't have a way to track that, that's something you want to start thinking about like right now. And it does offer a public health emergency expanded leave up to 80 hours. And there is some nuances of how the sick leave works with the 80 hours. Again, we're just going through speed dating. We're going to keep going along. If you have further questions after this week, be happy to go into it. So kind of, how does it work? How does it affect? So reasons for use. The Healthy Families Work Act that was published back in July 1st, question mark? July something. It was July something. It was the initiation of where we sit now and then where we'll sit on January 1st. So it laid out.
July 15th. That's what.
Darn it. That's why I said question mark. I'm like, I don't think this is right. Anyway, there's probably, and our next slide will go through it, but there's about 3 or 4 reasons, 5 reasons that you can use it. The accrual purpose is pretty straightforward. It's 1 hour for every 30 hours worked. So again, part-time, full-time. If you don't track exempt employee hours now, maybe you want to think about adding standard hours to your payroll so that you start tracking that on a weekly or bi-weekly, however your payroll system. And then some legal considerations we'll go into very quickly. But what are the reasons you can use this for? Well, I mean, it goes without saying, you're ill, you have a sickness, whether it be physical or mental, or an injury outside of workers' compensation. So there is some nuances to that. You're out obtaining a medical diagnosis for, a treatment of some sort and preventative health care. So, I mean, that's pretty common sense. The new parts to it, or not the new, but that became effective in July, is domestic abuse, harassment, and sexual assault. We already have a law that provides up to 5 days of unpaid leave for domestic abuse and sexual assault. Now it can be paid. Some of the other reasons would be availability to care for an employee's family member, all the same reasons for yourself. I would encourage anybody who hasn't read the bill or look a little more into the guidance. There is some broad definitions of what an employee's family member looks like. So it's not, my mom, my dad, my children. It's a little more expanded in nature, and there's a little room for a lot of what ifs. And then, of course, the pandemic. Right now, if you're following right now, the governor has the pandemic, the current public health order is in place through the end of the year in terms of the current paid sick leave. The question is, will they redo or extend into 2021? Because in theory, when the end of this year, the public health order should expire, and that 80 hours is not automatic on January 1. So we will need a new public health order or for him to extend the current one. Next slide. Okay, again, we've already talked a little bit about the accrual, 1 hour for every 30 hours worked. Again, really important to work with your payroll company now. And the other interesting thing is when the employee is hired, the accrual starts right away and they can use it right away. Actually, they can use it right away.
Yes.
And they have up to 48 hours. And then the public health emergency is the 80 hours. There's been a lot of questions. Well, what if I'm COVID and it coincides, and they do run concurrently. So they don't get 80 hours plus 48 hours. So there is a little trickiness to that. And then the rollover requirements. Commission employees, this seems to be the biggest question, is how do you determine what that pay is? You're going to have to kind of go back and look at some average wages to assign what a commissioned or a piece rate employee. I think there was like 2 or 3 different types of employees that may not have an assigned hourly wage. But at the end of the day, it can't be less than minimum wage. Use it or lose it. This is not new now per se, but December of 2019, anybody who had use it or lose it in their current sick leave policy. So for example, if you already offered it, or I'm sorry, for your vacation, just as a throw it out there as a side note, you can't forfeit vacation. Now on the sick leave, yes, they won't be paid out at time of termination, but because it does roll over, it's not a lose it kind of situation. It can cap at 48 hours, and they don't have to earn above that cap, but you do have to carry it over so that they have at least up to 48 hours. Last little part, which is interesting, if they're rehired within 6 months, you have to reinstate whatever balance they had at time of termination. Next slide. Compliance. So this is pretty involved, so I'm going to really go through it real fast. But the hours, I would just check your current policies. If you offer PTO right now, and that's currently covering your sick and vacation, that's something you need to relook at. And then just to make sure that your current policies meet up to the 48 hours. Documentation. This is a nuance. Most employee handbooks say after 3 days, if you don't call in and you're a no call, no show, we consider you voluntarily to have resigned. Well, the law actually says now an employee has 4 days to provide a medical certification. Therefore, your policies, which you may have in place for them to call in sick, still exist. They're still important and you still need to have them. But what happens if they don't show up for 4 days and they don't call? And then on that 4th day, they come back and say, I was in the emergency room. There was just no way for me to call, and you've already terminated them. You may have a problem. It's not as simple as it used to be. So if they can provide that valid medical certification and there was no way that they could have fulfilled it, you still may take disciplinary action in terms of they didn't do some other things to try to call in, but it cannot result necessarily in an adverse employment action. Record retention, everything has to be 2 years after date of termination. That again is no different because I think payroll is 3 years, so that's not new. The posting requirements, that's pretty important. $100 per each violation. And as I've read it, per each violation means if you didn't post the required posting and you had 100 employees, that violation is per employee that they didn't have the knowledge to see said poster. That can be very expensive. So if you don't post the poster, that's a risk you're taking. The other thing is, guess what? You have to give them this, just like the comps order, you have to provide this posting and or put it in your employee handbook. So either or. What if your business is closed? No, you do not have to pay the leave. Next slide. You know what? I could spend a lot of time talking about what type of documentation is right and so on and so forth. Foreseeable leave notices. Actually say employers can still adopt reasonable procedures in writing, should provide notice, i.e. foreseeable notice, but you cannot deny their paid sick leave, nor non-compliance of following the policy can result in an adverse employment action. So again, this sick leave is there to protect them in the event of an illness or an injury that require them not to be at work. I'm just going to have to kind of go through that. Privacy, if you're a HIPAA protected employer, but even if you're not, you shouldn't be sharing protected health information of your employees. It should be on a need to know, your HR person or your designated person who collects that information. Next slide. I will probably want to touch on this in somewhat detail. Retaliation and interference. This is super important. They have said the paid leave cannot be counted as an absence that'll result in firing or any other type of adverse action. Employees cannot be required to find, like maybe in restaurants, well, you need to find someone to cover your shift. You can't do that. If they need to be out sick, you're going to give them that sick leave if they have it available and they've earned it, but you can't hold it against them and tell them they have to go find someone to replace them. You can't threaten to fire your employees or retaliate because they took sick time. Again, they're very strict on this. And more importantly, employees need to still make that good faith attempt to give the notice. But if they don't and they make a complaint, and you cannot, like any other complaint, you can't take adverse employment action because they went to the DOL or the CDLE. You can't say, well, you know what, you've made my life miserable, goodbye. So next slide. Okay, really quickly, things to remember. I think talk to your payroll people. Do that as quickly as possible. This is for part-time and full-time employees. And I've had a lot of people ask, well, what about temporary employees? If they are an employee, they are eligible for this. You don't get to pick and choose and segregate and say, I'm going to carve out this class. If they are an employee and they are on your payroll, whether they're part-time or full-time, they are eligible for this. What else? Employees getting rehired in 6 months. If you have a pretty high turnover workforce, maybe you see a lot of people leave during the summertime, they come back, they leave. Remember, you've got to keep good records to go back and reinstate that accrual at the time they left. Next slide. And we have lots of, comps. Okay, so comps. The Colorado Overtime Minimum Pay Standard. Somebody just asked, well, I have one, it says 36. The comps order is updated annually if the minimum wage changes, which we know now and forever, most likely it will, because Colorado made a decision 5 years ago to tie minimum wage to the consumer price index. So as it goes up, CPI goes up, minimum wage will continue to go up. So pretty much now and going forward, you should see a new comps order. What are some of the things that you need to think about in terms of the comps order? I would say definitely look at the exemption status. Everybody knows for FLSA that you're exempt. The exempt status, I believe, is like 35,000 and help me. It's like 500 and something, question mark. But Colorado has a new exempt status. So to remain exempt, you have to, on January 1st, 2021, earn $42,500. And for the next 4 years, or 5 years, that will continue to go up $5,000. So if you have a supervisor who is currently today earning $40,000, a couple things need to occur on January 1st. Either you need to increase them to the $42,500, or I would say right now, you can make them hourly. But if you choose not to, understand year over year, their pay will escalate $5,000. When it gets to that 5th year, it will also be tied to the consumer price index and will continue to escalate. So this is a big new area. Not a lot of states do it, but Colorado has made the decision that we are going to set a different standard for our exempt employees. Some other things in comps order that you really want to think about. They've really redefined how you need to look at break periods. They're specifying, they've broken it down in incremental hours as to when an employee should get those break periods. But more importantly, anything over 5 hours does still require that 30-minute uninterrupted duty-free meal period. And then the same requirements that, they need to be relieved of their duties. In addition to the paid sick time, other kind of nuances that you want to think about and how they work hand in hand with comps. They both have posting requirements. The comps order has what's called an acknowledgement that you were supposed to have had your employees sign on July 15th when you provided them the new poster. If you have not done that, I would highly encourage you to go out, pull down the poster. We have an acknowledgement that we came up with to acknowledge that. If you don't have that or you haven't done that, you need to do that. Going forward, you can either have that in your handbook, i.e. a printout of the poster, or all the context of the comps order can be in your handbook, and that will suffice because typically people sign off on handbooks. Now, what about those companies that don't have handbooks and maybe they have remote workers? You need to get them the poster and you need to get an acknowledgement, and you need to do that yearly because it changes yearly. As you update your handbooks yearly, you need to make sure you update that comps order. Some final things to think about if you don't know this. This past November, there was a lot of things that happened in terms of the elections, a lot of changes. Doesn't matter what side of the fence you're on. We had a very pivotal passing of a proposition. It's called 118. Colorado has passed a paid family medical leave act, and that starts January 1st, 2023. And that is applicable to all employers, all. So I think I did it in 15 minutes. I rushed through it. So there you go. More to come. You know, I know Amanda does amazing webinars, so stay tuned. We have lots of them coming up in different areas that we do them. So if you check out our website, you'll keep track of when we have a calendar of all the different trainings that we offer.
Yes, I love it. And Britt, thank you so much. She's been giving us some information. That federal level is 35568.
I heard you, Britt.
Of course, right? That being said, I know there are some questions that we did not get to. I know a couple are from some clients, so we'll make sure that we circle back with you on those ones in particular. But I was trying to get through them as fast as I could. If for some reason I was not reading your question exactly what you were trying to say, the one thing that I do want to share with everybody is, I don't have it here. Okay. Thank you. But what I will share with everybody, and maybe we can put into the chat really quickly, Jeannie, is just our email that goes to both Jeannie and myself is hr@hrxservices.com. So you are always welcome to email us there, and then we will get back to you as soon as we can. We really appreciate everybody's time and attendance today. I know there's a lot to do here in an hour. We could spend hours and hours on this. So hopefully Lisa gave you some general information. Take that back, come back to us, ask us questions, start looking at the regs, and then seeing how that really applies to you. You've got amazing partners that you can work with. We know some of them. And so please make sure you know that you have people you can reach out to. So that being said, yeah, go ahead.
I want to thank Michael for encouraging us to do this with Shirazi Benefits. Yes. So thank you very much.
That is true, 100%. Also, thank you. So if you do have any further questions, once more, hrxservices.com goes to Jeannie and myself. Otherwise, we want to thank you for your time. Apologies for a little bit late, but I'm pretty proud of us, Jeannie. We rolled that as fast as we could. So once again, thank you all. And I will send out the slides and the recording as soon as we have that, probably early next week. All right. I think that's all we got. Thank you very much.